And this hearing is being recorded on Zoom and live streamed on YouTube.
And of course, in reality, we're here in a number of cases. That is the first caption. The other, there are additional 9 cases, I believe, in addition to the one listed. And we're here on defendant Guy's motion for an evidentiary hearing and/or exclusion of evidence offered by the prosecutor pursuant to MCL 768.27A, B, and/or Michigan Rule of Evidence 404B. So, as an initial matter, counsel, why don't you place your appearances on the record?
Good morning, Your Honor. Elizabeth Bartlett for the people.
And good morning, Your Honor. Mark Hunting on behalf of Mr. Guy. I think both Ms. Bartlett and I are not necessarily in our offices at the moment, so apologies for the more informal sort of attire. I will also advise the court, I think Elizabeth's driving. I'm in a hotel room with a 17-year-old daughter sleeping behind me. If she pops her head up, don't be surprised. That's just my kid.
Very good. And I did understand that both parties were fitting this in despite vacation plans, just in order to accommodate the court schedule, which I am grateful for. And I hope, Ms. Bartlett, you're not driving, you're just a passenger.
That is correct. I'm absolutely not driving.
Good. Good. I couldn't bear to have a crash on my conscience, especially going into Easter. So, all right. Well, all that being said, Mr. Hunting, I'll let you lead off. But before I do that, I'll give you an initial impression. I did read the briefing, and my thought was, well, you know, we've got some 10 alleged victims here. And of course, the victims are going to testify as to the events that occurred in their individual cases. And that will be, or could be, 768A evidence. And in fact, is the reason why we've consolidated the cases for trial, is to avoid both the inconvenience to everyone and also the trauma to the victims of, in effect, doing 10 separate trials. So my thinking is that the victims themselves, there wouldn't be much point in bringing them in for an evidentiary hearing because we're going to hear from them at trial. Some of their testimony may be objectionable. Some of it may be subject to cross-examination by you, Mr. Hunting, based on inconsistencies with prior statements made. But in any case, that is all going to be part and parcel of the trial anyways. Specifically regarding the 10 victims, what are your thoughts on that?
Your Honor, I agree with you in the sense that part of the reason for consolidation was the sheer number of victims, the sheer volume of evidence that's been exchanged and disclosed. And absolutely, nobody wants to try 10 individual cases with all or the same victims. My concern is not so much with what I have already elicited or Elizabeth has already elicited by way of their testimony, or for that matter, what they have already identified or told to the police in the various times that they've talked to the police. My concern is as follows. Almost every single one of the victims, not all of them, I'd say maybe half, to be fair, maybe half of the victims, make these generalized statements that, well, this happened so many times I can't count, and I can't remember specifics of every single one of these instances, but it happened every time I went to gymnastics practice, or it happened every time I went to my sister's house and spent the night. And I am unable to cross-examine effectively on a statement that said it happened every time, but I can't remember the specifics of it. And in that sense, I think that it is overly prejudicial. I'm not saying it's not relevant. I mean, the prosecutors write in their response brief when they say, hey, look, I'm not arguing that this potential evidence is not relevant. I'm arguing that it's unduly prejudicial if there are no specifics behind it and there is no effective means to cross-examine on it. It's easy for somebody to say, well, I remember 1, 2, or 3 times, and I can give you specifics on the 1, 2, or 3 times, but it also happened another 10, 15, 17, 30 times. But I don't remember specifically those, but they would be similar. Okay, well, you know what? My guy's charged with 23 counts, 1's kidnapping, 22 are CSE offenses. And frankly, if 10 victims and 22 counts of CSC is not enough, they feel that they need more, then maybe the case is not as strong as they maybe think it is, because I don't think that it's fair for me to have to go into a trial. And in particular, I shouldn't make it about me. It's really my client. It's not fair for us to go into a trial knowing, to be fair, knowing certain specifics about which has already been identified and or testified to, but also having to prepare for an on-the-fly, wait a second, I also remember the following, or I also remember the following here. Because I'm not saying Elizabeth knows it. I'm not saying that they've shared that information with Elizabeth or with the investigating officers, but in that sense, it is unfair and overly prejudicial, despite relevance, overly prejudicial to my client. Now, again, that does not apply to all of the individuals that are listed on their, the potential list under these statutes and rules of evidence. I do respect and appreciate the prosecutor's response where they do kind of identify a certain number of people that, hey, we're not going to, trying to elicit information from these folks. But still, I don't know exactly how we prevent it, because once it happens, and yes, there can be a limiting instruction, I get that, but once it happens, what do we do then? And at least with respect to the victims, I am perfectly happy, and I'm sure Ms. Bartlett is not, but I am perfectly happy basically saying, okay, whatever they have shared with the police to this point, either in written format that's contained in a police report, or they testified to at the preliminary examination, they can talk about that, even if it's not the basis of a charge. Okay, even if it's just extraneous to that charge, but it provides context to whatever it is that may or may not happen. Similarly, the non-victims, of which there are at least a handful now, anything that has been put in a police report that I've had access to, that I know about, I'm happy to be able to cross-examine that, because at least I've got the information. But if someone who hasn't testified yet comes in and says, oh yeah, I told the police about this one instance, but I also know now, or remember now, the following, boom, 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 where does that leave my client and myself? Okay. So I guess what I'm saying is that anything I know about, anything that's been provided, I think that's fair game. But if you read the preliminary examination transcripts, there are a number of instances where they say, hey, a whole bunch of this stuff happened, but I just can't remember it. And what happens when somebody shows up and says, I now remember it? How do we deal with that? And that's for you to decide, Judge. It's not for me to decide, but that's for you to decide. So with respect to both the victims and the non-victims alike, I guess I'm requesting that an order be issued that says, yeah, they can testify to these things, but it's only testimony that's already been done or outlined or stated under oath, or something that's found in the police report. They can't sort of go off the reservation with a new claim, new allegation, or new specifics that have not previously been provided to me. And the only way it gets provided to me is if it's also provided to Elizabeth and prior to that, probably an investigator. So that's my thought, at least on both the victims and the non-victims. I haven't gotten to the police officer testimony yet, but in response, very long-winded way, in response to your question, that's my feelings on it.
Okay. No, I appreciate that. And I guess there are two parts as I hear it then. And one is the objection to, well, I mean, you make the point, and I did note in reviewing the briefing that there are several victims and non-victims that say along the lines of, I can't remember how many times it happened or specific dates that it happened, but I can remember it happened, for example, every time I visited his apartment. Every time we were in this situation, this happened, potentially multiple times, but then limited specifics to one or two instances that came to mind. And I mean, I guess it's not terribly inconsistent with memory of old events, and that you may remember something that happened frequently, my drive to the courthouse, for example, but the one time I got pulled over because my license plate, I forgot to put the sticker on it when I renewed it. Well, I remember that because that doesn't happen. That one for, it was a little bit different, and it sticks in my mind. So and are you asking that we not have any testimony at all along the lines of, well, this happened numerous times, but I can't remember the specifics of it?
No, Your Honor, because as I said, I'm aware of that.
Okay? Yeah, okay.
That's something
you're okay with that. You can cross-examine on it.
Well, I can cross-examine on the numbers. My problem is if one of these witnesses comes in and testifies and says, yeah, I previously said that it happened, 15 times, although I just specifically remembered at the time I testified 2, but now I remember 7 more. And here's what happened the 7 other times. What do I do with that? Also, I'm being presented with that mid-trial, well, frankly, it'd be under direct examination. And now what do I do with that? I had zero opportunity prior to, it's not the basis of a pending charge, unless Elizabeth was going to try and amend at the end of the case. What do I do with that? And that's my concern, because frankly, that happened to multiple witnesses during the preliminary examination testimony. They came out with new specifics that was not contained in any police report, okay, and therefore not shown to either one of us, frankly. I mean, I think Elizabeth was as surprised as I was. And they said, oh, well, this also happened. No, I didn't tell the police that, but I remember it now. What do we do in that situation? Because if there's 15, 20, 30 other times that supposedly something happened, there's a decent chance, if you ask me, that somebody's going to remember some specifics and want to talk about that beyond just the pure number that it happened 15 times. That's my concern, Judge. And
yeah, no, I get it. And I think it goes to right, the nature of your, I mean, obviously we have this prior to trial, 15 days prior to trial, you're entitled to a disclosure of the witnesses and a summary of what they're going to testify to. And Ms. Bartlett's provided that, albeit in a large stack, because we've got a large number of potential witnesses and victims here. And in that stack are these more ambiguous statements that are broader that could expand. And I mean, frankly, you know, and I also think about the nature of memory. Well, of course, when my memory gets jogged about the specific time I got stopped by a police officer because I didn't put that sticker on my license plate, well, it's highly likely I might think of other instances, you know, that all of a sudden were similar or connected to that memory. I'm thinking of those movies that everyone watches with memories and emotions, you know, depicted as cartoons. You know, our brains aren't like, it's not like computers where you can say, okay, I want to open up file A and file B, but, you know, sometimes you get a little bit of C, D, and E along with it, just because of the way our brains work. All right, Ms. Bartlett, what are your thoughts on potential previously undisclosed specifics that could come out during trial?
Thank you, Your Honor. Well, you know, there's no legal basis to limit their testimony in any way. And the fact that they were abused over a period of time, it's consistent that they would not be able to pull back every single memory. And for us to limit them and say, if only if you've ever previously disclosed this, can you talk about this in trial? Because the only rule that they are given is tell the truth. If you don't remember something, say you don't remember. They can be cross-examined on new sexual assaults or new memories that they have developed. Most of these girls are struggling and are in counseling. And so going through counseling can help them, you know, think back to results, to process them more. There's absolutely no legal basis to limit them on what they can testify to, as long as it's their memory. You know, defense counsel did a fantastic job cross-examining all of the victims on things that they did not disclose previously, but then remembered at the prelim. That's very likely to happen, given that many of these girls were assaulted for long periods of time. It's impossible to expect a victim going through something like that, especially as a child, to recall everything and regurgitate it to a detective or a forensic interviewer or anything like that. We don't require that of our witnesses. They're subject to the questions we ask, and the cross-examination of defense counsel will no doubt, you know, ask of them. So I would ask that they not be limited. You know, it's like that for every single witness. You know, of all the trials that we've had, there's always new testimony that's always surprising to the defense or the prosecution. But we don't ever just tell witnesses. You're limited by what you've already told people. You know, defense counsel, again, will have that ability to cross-examine and say, well, you never disclosed this before and you're saying it now. So limiting them in their testimony is not, there's no basis under the law, and it would be unfair for each of the victims to recall that I did disclose this, did I not, and limited to this, am I not? We don't ask
Your audio's
any
breaking up a
witnesses.
little, Elizabeth.
Oh, I'm sorry.
That's okay. Yeah, no, I think I understand your argument, and what we're running into here is you know, sort of the tension between, well, you know, Mr. Hunting and his client are entitled to a certain, you know, at least a minimum of 15 days of disclosure so that he can prepare, you know, a reasonable set of questions for each witness on those incidents. And then On the other hand, right, we don't know. And, you know, a testimony about a specific incident that has been disclosed may come out differently. And witnesses may come forth with additional evidence or more recall than they did at the time of the prelim. And I guess the first question I have, you know, and part of it is the fairness there, and I understand, right? It like I said, part of it we're dealing with here is the way that human brains work. They don't necessarily recall every single detail at the moment, like a computer. That is a process. However, I think particularly in regard to now, I remember a different incident, and it happened on X and so a date, and here's exactly what happened. And I wasn't able to recall that before until I got on the witness stand today. Well, you know, I guess the witness inherently has some explaining to do as to why they're recalling it today, but sometimes witnesses can. They can say, you know, frankly, I've not, you know, just out of protection for my own mental state, not thought about these things at the length that I've been forced to at the trial. And that's pretty understandable if they do that. Charged assaults that you're talking about, those additional details.
Right, right.
Yeah. Yeah. And I mean, right. And to some extent, your questions are responsible for focusing the witnesses on the charged assaults. And then,
But
you know,
Your Honor, with all due respect, and my apologies for interrupting. When Ms. Bartlett says that there's no basis in the law to exclude any of this potential testimony, that runs directly counter to her obligations to provide notice of this exact information under the statute she's providing or arguing that this evidence is relevant under. Okay. If she didn't know about it, or if her investigators didn't know about it, we wouldn't have gotten these notices. And again, my concern is less with the stuff we know about and more with the stuff that we don't know about. You know, any previously undisclosed, specific, or even general to that extent, allegation of some sort of inappropriate sexual activity. Right now, I am preparing, my client and I are preparing, as Elizabeth is too, to fight out 22 counts of CSC. Is that going to be 40 counts of CSC at trial? Even though they're not charged, I still got to try and dispute those, because you know how juries work. Okay, well, maybe we're not proven beyond a reasonable doubt on this one particular one, but she said it happened 18 times, so it probably happened. I mean, without the specifics, how do I fight that?
Right. I mean, I have complied with the court rules, with the statute requirements. I am required to give him their statements that they have made, and we have done that. We have turned over all of their statements, any recorded statements. But defense counsel is not entitled to like a transcript of what each victim or 404B, 768, 27A and B witnesses are to say. He doesn't have that right to pre-try the case before trial.
And I agree. I'm sorry, Elizabeth. I agree with all that. 100%. I agree with all that. It's been provided. It's been noticed. I'm not entitled to depose these people. Absolutely not. But I am entitled to try and protect the integrity of the trial and the case that is brought against my client. And I am entitled to find out or have it excluded any testimony that is not cleared or falls in violation of 403. And that's what we're talking about here. We're talking about something that could be 100% unduly prejudicial to my client that we don't know about, but you expect, Elizabeth, that there's going to be some testimony from these people that goes beyond the specifics of the charges that have been authorized.
Well,
I'm not asking for depositions.
1 second. 768 and 404B witnesses, I have required notice and of the content of what those witnesses are going to say. I don't anticipate anything beyond what has already been disclosed, other than maybe additional details that I am required to bring out of the witnesses. You know, credibility and all of that has to be factored in, but there is no basis to have an evidentiary hearing just so that defense can have a first chance at hammering these witnesses and victims. We would have to wait for the transcripts of all these people before trial so that he can I don't know. It's just never been done. No defense attorney ever says, I need to have an evidentiary hearing to make sure I know exactly what all of the witnesses are going to say at trial. The preliminary exam ran where all of the victims testified. I have complied with the court rules at every step. There is no legal basis to require anybody else to come in and have an evidentiary hearing so that the defense can have two bites of the apple.
Your Honor, again, I understand what Ms. Bartlett's talking about. I'm not asking for two bites of the apple. I'm not. I'm asking for one bite at the apple of anything that hasn't previously been disclosed. And there's a huge difference there. Okay, a huge difference there. None of this was discussed with any of these witnesses or victims at the preliminary examination. If the court doesn't want to have an evidentiary hearing, and if Elizabeth is saying, hey, look, I am not going to ask these victims or witnesses anything beyond what has already been provided in the police reports or any of their statements, audio or video recorded, that's fine. We can limit everything to that. And I am perfectly happy with that. But I guarantee you, somebody's going to go off the reservation. Somebody's going to start talking about something that they've never talked about before. Elizabeth and I have been doing this long enough, and Judge, so have you. Happens all the time in a trial.
But Judge, all the time in trial, I've never ever been limited to asking a witness of any sort what is questions that as it pertains into a police report. I've never been limited to that. That is not a valid objection. That is not grounds to not ask the question. It's ripe grounds for cross-examination.
Yeah, well, and I think that there are some important distinctions that need to be made here. And I think there is certainly no intention, and I don't think Mr. Hunting's asking either, to say about the charged events. Of course, the expectation, in fact, is that at trial, we might receive more detail than even at the preliminary examination. After all, the standard of proof higher. This is the trial of record in the trial court. It is the best opportunity to place, those in detail and in-depth facts about each particular charged incident, particularly on the record. I don't think Mr. Hunting's asking to limit any testimony about the charged incident. The objection is centered around uncharged and other offenses that have been referenced, because many of the victims and some of the non-victims have said, well, this did happen multiple numbers of times, but I can only remember one or two. And in the case of the victims, those have mostly been charged. It's mostly charged conduct in the non-victims for a variety of reasons. Some of them were not charged, and thus we don't have because obviously in the preliminary examination does provide as close as defense counsel typically gets in terms of a transcript or the ability to elicit the details of the events that led to the charge. And also to focus those. And that, of course, is part of the intent of the pretrial process is to focus on the events that are subject to the charges. The real objection here. However, I think that absent Ms. Bartlett's awareness of any specific incidents that she's going to question about ahead of time, I've heard her say that her questioning, and I would expect at court, and of course it's bounded by relevance and also, frankly, the rules of presentation of witnesses say that Ms. Bartlett can't just say, well, tell us everything you remember about your interactions with Mr. Guy, from start to finish. That would call obviously for a narrative response and allow a witness to go and ramble away. And even on direct examination, we don't want witnesses to go that far afield. So Ms. Bartlett is going to naturally focus the witnesses on the events they already testified to. Go ahead, Mr. Hunt.
Yeah, exactly, Your Honor. I'll follow the court rules, the rules of evidence. I'm not going to break any of the rules. I'm well aware of what they are.
Yeah, and again, just so that we're all clear, I am not suggesting that Ms. Bartlett or anybody in her office, or frankly, anybody who's been investigating these alleged offenses has done anything wrong. I'm not saying that at all. My concern is this, Judge. The way you just described it was charged and known. Ms. Bartlett is not going to intentionally get into information that is or go beyond information that is charged and known. And the charged part is obviously the basis of the charges. And the known part is even uncharged things, but it's known right now to all of us. It's known. We know what they have said, either via police report or preliminary examination testimony or video or audio recordings. My problem is uncharged and unknown, because that's out there. It's in police reports. Uncharged, meaning multiple charges could have been brought for additional victims and non-victims alike, and unknown but stated, meaning, oh yeah, it happened all this other times, but there's no specifics on that. And that's the problem from my perspective. Okay.
Yeah.
If you want to give
these types of cases.
I'm sorry?
That is always the that is always the case on assault cases where it's happened over a period of time. Every single victim says that.
Well,
But we don't
that's-
limit their testimony. There's no legal basis to do that.
But there is a legal basis to do that, Your Honor, and that legal basis comes from the precise statutes that they are bringing these witnesses in to testify under. I am entitled to a quote summary of their anticipated testimony,
Which
I've
has been
gotten.
provided.
Excuse me, which I've gotten. That summary does not include any specifics with respect to 20 other times that this is claimed to have happened. All it says is 20 other times. What if, and this is what we've got to protect against, people. What if victim 2 gets in there, Elizabeth, and says, oh yeah, I told you before it happened like 20 times, and I remember 18 of them. And then she starts going into that. Where does that lead?
Well, and I think, just in terms of practical, what happens at a trial, if that happens, unanticipated, perhaps more detailed, and, perhaps frankly, irrelevant testimony from a witness about some interactions that now have been remembered that previously were not remembered. And I think the only way to deal with that is objection and at trial. I think even if we did a preliminary, an evidentiary hearing with regard to these witnesses, we would certainly rehash everything that's already been said in the prelim, and we might get some additional detail, regarding those charged incidents. And, it's very possible that someone would talk about an uncharged incident. However, certainly my intention is to focus on the details of the charged incident. Certainly the witnesses can talk about, and my expectation would be that it's in less detail because the notice about it is in less detail, and that, well, this is something that happened 15 times or almost every time I went over to his house. We may hear that sort of testimony, but right. Yeah. I wouldn't expect that we would then rehash each one of those incidents when she visited the house, because now, you know what, Judge, now I remember, in February 2 years ago, here's the way it looked in detail. I wouldn't expect we're going to go that far in depth, even if a witness does remember at this point. And the reasons are somewhat practical, and that we've got to get this trial, keep it moving and get it completed within the time allocated, and somewhat, to accumulation, and that, already the witnesses are going to hear, as Mr. Huntings pointed out, specifics about at least 20 charged acts of CSC. And I think, that was another, kind of takeaway, and that, if there are, some more specific details about, another 10 acts in there that could have been charged but weren't, well, at what point do you say, it's getting to be so much that the jury can be confused, overwhelmed, that we're getting to that kind of cumulative point of evidence. But all those are inherently things that, at least with regard to the victims, I think have to be decided at the trial. And I think, the non-victims are somewhat separate situations, and my intention would be with the victims, if they stray too far afield, there are a whole variety of objections that I would expect Mr. Hunting will make, including to relevance and things like that. And, those all have to deal with in the course of the victim's testimony. The non-victims, present a little more of an issue, and, frankly, perhaps a little more compelling argument to have them in for an evidentiary hearing. So let's go to the non-victims that may be called, because those incidents are a little older and a little more general, because, there was no preliminary examination. Let's talk about non-law enforcement, non-victims that might be testifying out here, and the necessity of possibly bringing some of those folks in to the evidentiary hearing.
Well, Your Honor, since it's my motion, I guess I'd probably go first on that issue.
Yep, go ahead.
I identified the handful, a little more than a handful, I think, of non-victims that at least Ms. Bartlett initially had listed under her 404B and 768 notice. I am led to believe, based on the most recent witness list, that at least a few of those people are no longer being actively called by the prosecutor, by the people as witnesses. And specific to that, I think we're talking about Wagner, Ahmad. There's a number of people that were removed from your most amended witness list. Elizabeth, is that fair and accurate?
Yes, it is. Yep.
Okay. So if I'm understanding the response that I got Tuesday from the people with respect to non-witness testimony, it is only individuals who claim they were sex assaulted, although they were not charged. Is that fair? I'm not going to outline all the names, but there's like 5, I think, of them. Is that accurate?
Right, for the 768-27B, aside from the officers. Yes, the other,
Well, okay. I don't mean to interrupt you, but my understanding is you guys are not seeking to, any 768-27B. You're just looking at 27A now. That's what the response said.
oh, yep, that is right.
Okay. Which would apply to both victims and non-victims alike.
Right.
Now, I can tell you this much, Your Honor, with respect to at least an evidentiary hearing on the non-victims, non-law enforcement. Again, to a certain extent, it suffers from the same sort of what's out there question. Yes, these women provided statements to the police. However, they did not testify at the preliminary examination, which is fine. They don't have to. But some of them have generalized complaints. Other ones have more specific complaints. The same issue, in my opinion, is okay, to the extent that I actually know what they might testify to, I'm okay with that. Your Honor,
Judge, oh, I'm sorry. Maybe this will short circuit the officers. They are
Yep.
only testifying to the things in the report. They will not go outside the bounds of what's already been disclosed in discovery or police reports. So.
Okay, no, that makes sense. I did, as I read through there, I noticed some of these officers downloaded reams, it appeared, of information, photographs, call logs, things of that nature. How much of that, if any, are you planning on presenting?
Yes, Your Honor, there are photographs and books obtained from the defendant's storage unit that I anticipate will come in. There's also videos and recordings from his devices here in Michigan and also recovered from Florida, including CSAM. And so I provided notice of that as well.
Okay, and your intention is, because I mean, you know, I guess I think about the acts. How are they? Are they of the specific victims that are charged here?
Some of the photographs and videos that he had are of the victims. Some are of unknown victims.
Okay, well, I certainly can see how a video of a specific victim or a photograph or whatever might be relevant to the charges against that specific victim. How would the non-victim photographs or videos be relevant?
Because they are all taken with focus on their private areas. And so it goes to the defendant's mindset, his attraction to young girls.
All right, what's your response, Mr. Hunting?
Well, my response is a couple things. First off, at this stage in the game, intentionally, mind you, it has not been prohibited, but intentionally, the alleged child sex material I have not reviewed. And the reason I haven't reviewed it is I don't really want to unless I have to. So if ultimately this court decides that anything that might be CSAM or borderline CSAM will be admissible in trial, take a look at the material, and maybe there'll be some objections prior to its admission. I don't know. However, as a general sort of argument and objection, my client's not charged with CSAM. And if there are photographs that are not, for example, CSAM, and I think I know what some of those photographs are that Ms. Bartlett's referring to, I've obviously seen those. I expect her to use those. I don't have an issue with those. My concern with the law enforcement officers generally is what precisely are they going to come in and testify to? I mean, they can't testify to hearsay. They can't testify to talking to any of the victims that, or even alleged victims, or even people who are non-victims. They can't testify to what they had to say. They can testify to what they did, and they can testify to what they, theoretically uncovered. But I don't understand how that falls under 404B or 76827A.
Yeah, but it would come
Right.
in on 76827A. They would come in and say they're fair and accurate depictions of the items recovered from the defendant's property. So that's how that would come in. It would come in because child, that all comes in under 76827A.
Because it's all listed offenses.
Right.
And how, with regard to a non,
But bear in mind, it's still subject to 403. It's not an automatic comes in. It's still subject to 403.
Right.
And you got to make that analysis, Judge. I mean, like, we can argue about it. Elizabeth and I can argue about it all day long. But unfortunately, you wear the black robe. I should say, fortunately, you wear the black robe, which means it's your decision. So, to be honest with you, if it's going to even be offered, I think probably it needs to have an in-camera review. And maybe after I see it, if you're going to even theoretically allow it, I got to look at it. And then if I don't have an issue with it, which I suspect is not going to be the case, I think you got to do an in-camera review. I mean, if it was a direct CSAM case, that's different. But it's not a direct CSAM case.
Go ahead,
Ms.
it'll be a CSAM case in Florida. They're holding off on charging or extraditing him, knowing that we have the victims up here. I am okay with an in-camera review. There is over 30,000 images of child, and I have limited that down substantially. I've offered.
I wouldn't want you to look at 30,000, whatever Elizabeth would want to offer. I think I have to look at it, which again, like I said, I've been holding off on doing it. And then, Judge, you probably do too.
Yes, I haven't seen any, nor am I eager to review any. However, obviously, if they are going to be offered at trial, it would be important for me to review them prior to. And so I would ask Ms. Bartlett, how many images are we talking about as you think it through today that you're going to be presenting that would fall into that CSAM involving a non-victim category?
Goodness, the exact number I don't have offhand, but I want to say around 20, maybe.
Okay. Is it possible for you to send those to my?
I cannot send them.
Yeah, that's true.
But I am happy to bring them to a meeting in person to show you guys.
I think we should do that.
Would have to come as well because I can't hold them either.
Yeah.
If they're admitted at trial, then that's fine. But
yeah, let's conduct that, and I want to be conscious of that, and all the attendant potential fallout from it, and I think there are several concerns, all of the above regarding the material in the first place, and then secondarily, these are these unknown individuals that we might be seeing photographs of, or okay, so these are just unnamed individuals. However, it would fall into the broad category of CSAM, thus arguably admissible under 768A, and I think that somewhere along there we can certainly, because 403 does require me to balance it. And as you review that, kind of 403 versus 768A, well, 768A says, you can show these actions to prove acting in conformity with is stuff that we normally don't allow, character evidence, if you will. However, it isn't unfettered, because at the end of the day, the jury's going to have to decide, as I see it, as things currently stand, 10 different verdict forms regarding 10 specific named victims, and make the decision on those. So we're already going to be asking them to do quite a bit of detailed individual decision making in the context of a lot of information. So, my goal being to make that presentation of that information as clear as possible, so as to present the issues that they have to decide, in as focused a way as we can. Then I think the jury's capable of doing it, or I wouldn't have permitted the trial, to proceed in this matter. But I do want to be aware of the complexity of it. And, somewhat like a very complex commercial case, there are, at least in my experience, limits to the complexity that jurors can understand, right. And we're trying to avoid the scenario where they just throw up their hands and say, well, as Mr. Hunting said, this guy's a bad guy because of everything else he did, not the charged incidents necessarily, but let's convict him on everything. Or on the flip side scenario where, they feel like so much information is being withheld from them or not presented to them that they can't, come to a verdict, because Ms. Bartlett hasn't met the burden of proof. I think, there's a balance there, and that's what we're trying to strike. And I think that this pretrial motion practice has at least narrowed, some of those issues down in my mind, and also helped me focus on, what's likely to come up during trial. So I'm grateful that we did it. Thankful that you're both willing to make yourselves available, or you're at least nominally on vacation, and I hope you get some rest and relaxation because, obviously the trial is going to be demanding for counsel, the court, the jurors, everyone engaged in it, witnesses, everyone engaged in this trial is going to be called upon to expend significant energy in getting this done and done right. So. And boy, nothing I would like more than to do it right the first time and not have to do it again. So,
Understood, Your Honor.
Yes, thank you.
Hey, Liz, when do you get back?
Yep. I'll reach out to you.
I'm sorry. Okay. Yeah. Just so we
Yeah,
can
yep.
square
We'll
that up.
connect and
Okay. No worries. Travel
All right.
safe. Thank you,
thank
everybody.
you both.
all right. Thank you. I'll see you on the 10th.
Jake, I'll
All right,
set up
bye.
a video visit.
What was that, Mark?
I was talking to Jake, just letting him know
Oh.
I'm setting up a video visit.
Okay.
All right.